The Supreme Court decision in the case of Republic of the Philippines versus Helen Bayog-SAITO. In the present case, petitioner opposes the recognition of the foreign divorce decree on the ground that it was purportedly obtained by Helen jointly with her Japanese spouse, Toru. Petitioner avers that respondent cannot file and obtain a divorce decree jointly with her foreigner spouse because she is incapacitated to do such act under our national law. According to petitioner, the provision under paragraph 2, Article 26 of the Family Code only applies when the divorce decree was initiated or obtained solely by the foreign spouse. Petitioner submits that because the divorce decree sought to be recognized as grounded on mutual agreement of the parties, the provision under paragraph 2, Article 26 of the Family Code does not apply. Petitioner's contention is bereft of merit. In the landmark case of Republic of the Philippines versus Manalo, the court en banc clarified the scope of paragraph 2, Article 26 of the Family Code to even cover instances where the divorce decree is obtained solely by the Filipino spouse. In subsequent cases, the court noted that the prohibition against Filipinos participating in divorce proceedings will not protect our own nationals. Thus, the court held that it does not matter if it is the Filipino spouse who acquired the decree of divorce abroad. The court hereby quotes the pertinent portion of its ruling explaining the application of paragraph 2, Article 26 of the Family Code. Thus, based on a clear and plain reading of the provision, it only requires that there be a divorce validly obtained abroad. The letter of the law does not demand that the alien spouse should be the one who initiated the proceeding wherein the divorce decree was granted. It does not distinguish whether the Filipino spouse is the petitioner or the respondent in the foreign divorce proceeding. The court is bound by the words of the statute. Neither can we put words in the mouths of the lawmakers. The legislature is presumed to know the meaning of the words, to have used words advisedly, and to have expressed its intent by the use of such words as are found in the statute. Assuming, for the sake of argument, that the word obtained should be interpreted to mean that the divorce proceeding must be actually initiated by the alien spouse. Still, the court will not follow the letter of the statute when to do so would depart from the true intent of the legislature or would otherwise yield conclusions inconsistent with the general purpose of the act. To reiterate, the purpose of paragraph 2 of Article 26 is to avoid the absurd situation where the Filipino spouse remains married to the alien spouse who, after a foreign divorce decree that is effective in the country where it was rendered, is no longer married to the Filipino spouse. The provision is a corrective measure to address an anomaly where the Filipino spouse is tied to the marriage while the foreign spouse is free to marry under the laws of his or her country. Whether the Filipino spouse initiated the foreign divorce proceeding or not, a favorable decree dissolving the marriage bond and capacitating his or her alien spouse to remarry will have the same result. The Filipino spouse will effectively be without a husband or wife. A Filipino who initiated a foreign divorce proceeding is in the same place and in like circumstances as a Filipino who is at the receiving end of an alien-initiated proceeding. Therefore, the subject provision should not make a distinction. In both instances, it is extended as a means to recognize the residual effect of the foreign divorce decree on Filipinos whose marital ties to their alien spouses are severed by operation of the latter's national law. Significantly, in the recent case of Galapon versus Republic, the court clarified that pursuant to the majority ruling in Manalo, Paragraph 2, Article 26 of the Family Code applies to mixed marriages where the divorce decree is 1. Obtained by the foreign spouse, 2. Obtained jointly by the Filipino and foreign spouse, and 3, obtained solely by the Filipino spouse. Here, the divorce was initiated by Toru, who asked Helen to sign the divorce notification papers. She agreed by affixing her signature on the documents. In effect, the parties are considered to have obtained divorce by agreement when they mutually agreed to the divorce, which is allowed in Japan. After the acceptance of the divorce notification, the marriage of respondent and Toru has been dissolved as far as the Japanese laws are concerned, and Toru is then capacitated to remarry. Pursuant to the court's ruling in Manalo and Galapon, even though respondent jointly filed the divorce notification papers with her husband, the divorce decree obtained by the parties may be recognized in our jurisdiction. Hence, the Court of Appeals was correct in ruling that the legal effects of the foreign divorce decree of the parties may be recognized in our jurisdiction. In the process of judicial recognition of foreign divorce decree, the rules provide that before a foreign divorce decree can be recognized by the court, the party pleading it must prove the divorce as a fact and demonstrate its conformity to the foreign law allowing it. Specifically, for Philippine courts to recognize a foreign judgment relating to the status of a marriage, a copy of the foreign judgment may be admitted in evidence and proven as a fact under Rule 132, Sections 24 and 25, in relation to Rule 39, Section 48, Paragraph B of the Revised Rules of Court. In the case, the pieces of evidence presented by Helen, which consist of the divorce certificate, the notification of divorce, the acceptance thereof, the record of the family register of Toru, all of which are duly authenticated, as well as the duly authenticated pertinent laws of Japan, are sufficient to prove that in fact the parties have validly obtained a divorce under the laws of Japan. In the case of Racho versus Tanaka, the court found that the Japanese law on divorce was duly proven by the presentation of a copy of the English version of the Civil Code of Japan translated under the authorization of the Ministry of Justice and the Code of Translation Committee. Here, the court similarly finds that Helen duly proved the pertinent laws of Japan pertaining to divorce through the submission to the trial court of a copy of the English version of the Civil Code of Japan translated under the authorization of the Ministry of Justice and the Codes of Translation Committee. Verily, the fact of the divorce of Helen and Toru, as well as the Japanese law on divorce, have been sufficiently and satisfactorily proven by Helen. Hence, the court finds that the CA was correct in affirming the RDC's grant of the petition for judicial recognition of foreign divorce decree of respondent and her Japanese husband. More importantly, the dissolution of their marriage under the laws of Japan has capacitated her former husband, Toru, to remarry, and in fact, he is already remarried. Hence, the court finds no reason to deprive Helen of her legal capacity to remarry under our national laws.